Hello and welcome to this exclusive interview. Today we are talking to Justice Dr. Jane Ansah. She is the chairperson of the Malawi Electoral Commission. Welcome to this interview.
Thank you.
It's been more than 3 weeks now since the election results were announced. And I know that the process is quite hectic and stressful. What have you been up to from that time?
Oh, after the announcement, I'm leading my normal life.
Okay. Did you take a holiday maybe to just relax a bit?
No. I went for a funeral.
Oh yeah, I understand you traveled outside the country. Was it someone, a close relation to you?
Very close.
No, my condolences on that.
Yes.
Let's go straight to the elephant in the room, and that's the issue of the results of the 21st May election results. As we are speaking, there is a case in court where two of the opposition political parties, the MCP and the UTM, are disputing the election results. And the state president also made reference when they were doing a rally at Njamba Freedom Park that he felt that the Central Region vote was stolen from him. Does it come to you as a surprise that people are claiming that the elections were rigged?
Yes, it comes as a surprise. For the simple reason that they made the whole process transparent. You know that MEC is the elections management body. And at MEC, the number of staff is less than 200, including drivers, cleaners, and everyone. And when it comes to election management, we are managing the elections together with we are managing the elections, but those that are there that we work with are the stakeholders. And the biggest stakeholders are political parties. And there are institutions that were established to make the working together easy, so that both the MEC and the stakeholders are on the same page in the whole process from beginning to the end.
Are you, as the Electoral Commission, of the opinion that possibly the election would have been rigged?
I look at the process. According to the process that we put in place, I don't see any room for rigging. There are things that MEC had to do on its part. And in working together with the stakeholders had also to do particular things. For example, I'll take you through the whole process. From the time that the elections were launched last year, we were having meetings with the stakeholders through this body, NECOF, National Consultative Forum, where everybody that is affected by election is represented. In the NECOF, you have secretary generals of political parties present. They attend CSOs, they attend government officials, traditional leaders, even in the media, they also attend. So there's no sector of the community that is left out without representation. And at those meetings, we shared what was on the ground, what we are doing, so that everybody was in the know. And apart from that, MEC is a listening body. Knowing that we work with the stakeholders, we would share what we have put in place and then get a feedback from the stakeholders. Through that feedback, they will also tell us, maybe make a recommendation for certain things. We would look at them and then incorporate them if they are doable. For example, there were requests about inclusion of women, inclusion of women, the disabled, the young people. We looked at it as a commission, and we gave concessions on the nomination fees to women. Women were given 50% off, disabled, and the youth.
Yes.
That's one of the examples. And also, in the NECOF, together with all stakeholders, we came up with the codes of conduct. And those codes of conduct were signed for by those involved with an undertaking that they will follow them. There's a code of conduct for political parties and the candidates. There's a code of conduct for media houses, journalists, on how to play their part in educating and informing the nation on what is going on. There's a code of conduct for traditional leaders. So all these codes of conduct, MEC did not sit on its own and come up with them. But in a consultation, discussions with the stakeholders, we came up with them. And the stakeholders made an undertaking that they will observe and abide by their own codes of conduct.
Help me understand this. What I see is a pattern. Before the elections, there were allegations that some political parties were planning to rig the elections. Almost all the three major political parties, UTM, MCP, and DPP, made those allegations and claims. After the elections, the three major parties came out and said the election was rigged. And these are political parties that are sharing almost 70% of the total national vote that was cast. So the three major political parties are alleging that there was rigging in the elections. And the Electoral Commission maintains that there couldn't have been any rigging in the election.
You see, what I'm saying is that the process, the way it is, to us, it is watertight. Because the way that if two people are doing a thing together, if the thing has been done well, it is not one person, but both of them have made their contribution. If the things have not gone well, both of them have made a contribution. So in what I'm saying is that the process, we did not leave any stakeholder out.
Okay.
And the stakeholders had their part to play and make its part to play. And for the two sides playing their parts properly, there's no room for rigging. So we put all the necessary processes to ensure that there's no rigging. So when I look at the process,
yes,
I believe that the process is watertight.
Now let's look at what this process brought out. And I would like us to go back to see where all this started. I think for most Malawians, the first thing that sent a signal that things were not right was when you admitted that there were some forms that were altered using some correction fluid. And I'm reading what you said verbatim. You said, on the Tipp-Ex results, yes, we have received forms that are Tipp-Exed, and the Tipp-Ex is in the section which we talked about Friday, that they, referring to polling staff, were having difficulties balancing. It is a surprise to us that the forms are Tipp-Exed because MEC does not provide Tipp-Ex, and during training we emphasized to the hired staff that we do not provide Tipp-Ex, we should not see Tipp-Ex, and we're just as surprised that there is Tipp-Ex. However, the part where it is Tipp-Exed is a part that they are balancing the number of materials received, like ballots, those used and those not used. But on the part of captured results, they are intact. Did you establish where this correction fluid was coming from?
You know, this matter is in court, and I do not intend to give evidence to the media. I would rather leave it that when the time comes to give evidence, it will be given to court. But all I can say is that Tipp-Ex is a trade name. What that fluid is called is a correction fluid.
Yes.
And the correction fluid, if you check in the dictionary, you correct the errors. So that's what the court will find out, whether the correction fluid was used for positive or negative purposes. So that's a matter for the court.
But you are saying that we emphasized to the hired staff that we do not provide Tipp-Ex, we should not see Tipp-Ex, and we are just as surprised that there's Tipp-Ex. Why were you surprised that there was correction fluid used?
It's exactly what we are reading, because we did not provide. But why that statement was said, that they should not use the Tipp-Ex, because in all the other elections, the MEC has never supplied the Tipp-Ex, but the results will come with the Tipp-Ex. So that's why during the training, we emphasized that we should not see Tipp-Ex.
So, in your words, it was okay to use any other correction fluid other than Tipp-Ex. Am I getting you right?
No, I am saying Tipp-Ex is a correction fluid.
Yes.
But the Tipp-Ex is a trade name. So what I'm saying is, I am not giving evidence.
Okay, all right, yeah.
What I'm saying is, Tipp-Ex can be used for positive or negative purposes. And that is for the court to find out. And I'm not going to give any evidence.
I don't want us to go there, because obviously there are matters in court. But what I want to understand is, what was your advice when the polling staff, they have a problem that they have to correct on the form? How did you advise them to correct that form? In case, like here, you're talking about them struggling to balance. In an event that they were struggling to balance it, how did you advise them to resolve that problem?
We did not foresee that there will be those problems.
But you indicated that in the previous elections, there had been forms that were altered by Tipp-Ex, and that you made it clear that they should not use Tipp-Ex, in which case it shows that you anticipated that there might be, let's call it a temptation, to use Tipp-Ex to resolve a certain problem. So it might have been wise to anticipate that and advise that in this case, this is what we expect you to do.
No, we didn't advise them on what to do, because these are staff that are trained. The purpose of the training is that they should do the right thing. And when we say staff, it was not just one person, but there were several people involved. We expected them to do thorough work.
In the case that they really struggled with the balancing and they wanted to rectify it and stick to what you would consider the right thing, what would that right thing be? I'm thinking on behalf of a returning officer and his team who are really struggling to balance this, but they don't want to use the correction fluid. They need to do something that is going to be admissible and that is going to be acceptable by you. What would this person have to do?
No, as I've said, I cannot go into details.
Okay.
I'll let that pass.
But I would still presume that you still accepted these forms, because you seem to be referring to forms that you were getting that had alterations with Tipp-Ex. Did you accept to use these forms in the election results tallying?
That's what I'm saying, that I'm not giving evidence here. That will be for the court to determine. It suffices. What I have said suffices.
It does, but I'm still wondering, because any legal document, and I consider these forms legal documents, cannot be accepted in any altered form. Many examples have been given. I think the most popular example is a situation where you want to cash a check in a bank. Any alteration on the check is not accepted. You have to literally trash that and start filling it again. Now, when you were surprised that some forms were being Tipp-Exed, some parts were being Tipp-Exed out, how did you treat those situations?
As I have said, the matter is in court, and those questions will be answered in court.
Let's move on to something else that is equally interesting. Early in the voting process, it was discovered that the then Vice President, Dr. Salos Chilima's name had been transferred from his polling center to another polling center on, I think, Lukoma or Chizumulu. Did you follow up on that incident?
Yes, as I explained, during that time, that indeed we discovered that had happened, and we made a follow-up and found where who had done the transfer. Okay. And we said it is one of the hired make staff who was not with us at that time, but we gave the particulars and reported the matter to police for the police to investigate and get this person.
What did they say the reason was for doing that? Did you ever find out?
We don't know if the police have found the person and have interviewed him. We are yet to get a report.
Are you not interested to know if the police have done that, considering that this might have affected the credibility of the election process?
Yeah, we are interested, but we have not received a report from the police.
Have you tried to approach the police to follow up if they have been following up on this matter?
We do.
So 3 weeks after this investigation, or even more than 4 weeks, we still haven't gotten, you've not been furnished with any details from the police as to how far they have gone with this?
Yes, that question can be answered by the police, because MEC is not an investigative body. We did what we could do, identified who did the transfer, from which kit, and then gave all that information for the police to work with.
But the question you can answer is, don't you find it peculiar that it has taken them so long to follow up on this matter that we consider very critical and important? Are you okay with what is happening?
As I'm saying, I am not an investigator. And when you live with the experts, you wait for them. You can make a follow-up, where are we? And when you don't get it, you will not get up and do the work.
How long are you willing to wait for the police to come back to you?
Well, we have been following. It's not that we are willing to wait, but when they have the information, they will let us know. And in fact, when they do find the information, the process is that they look and interview, they look at the information when they have taken somebody, and they will take the matter to the DPP, Director of Public Prosecutions, if the matter warrants prosecution. MEC will be just invited as a witness by the DPP. That's how criminal law works.
Considering the level of preparation you put into this, wasn't it frustrating to you that something like this could have happened? Because I think, to me, it points at weaknesses in the system. The system must have been designed to check against these illegal transfers. But someone not only attempted to do it, but they even successfully did it.
You remember that after registration, there was a period for verification. And during the verification, it's also the period where we said those that want to transfer can transfer. So during that period, the transfers were made. And we are talking of millions of people that registered and a good number of people that transferred. Out of all those transfers, where there's a query is just one. I don't think it's maybe too much because it's just one person. When you look at the totality of the numbers we are dealing with.
You are on record as saying that you received 147 queries, but in the course of doing the press briefings at Chakhaza Hall in Blantyre, there was a time when you indicated that you had not received any complaints from the Malawi Congress Party, and the party was totally stunned to hear that, because they alleged that they had already filed more than 11 complaints to the Electoral Commission, and that the Electoral Commission had acknowledged receipt of these complaints. Do you recall having received these complaints, but still going ahead to say you had not received the complaints from the MCP?
If you can go back to what I said, you will get it correctly. In the end, I even gave the numbers of complaints in the presidential elections, complaints for parliamentary elections, and the complaints for councillors. And what I said was that there was one letter, one complaint that MCP gave. And I got the other complaints that we dealt with were from the social media. And I even explained each complaint and how it was resolved.
Just refresh our memory on what the nature of these complaints were, because I think most Malawians were curious to know what these political parties were complaining about. What is it exactly that the 147 complaints contained? What was it all about?
Well, it was various, and I said it.
Yes.
As I said, this matter is in court.
Yes, I know.
I'll leave it because I already explained in detail.
But still,
and if you can recall, most of them were for members of parliament and the ward, and I explained each and everything. So I cannot say much. The complaints that we received, we dealt with them and wrote back to all the complainants. Even during the briefing, I said it. When you go back, listen to the briefing, you will get it exactly what I said about the complaints.
So you are assuring us that all the 147 queries that the political parties lodged with the Electoral Commission were resolved?
Yes.
And this was communicated to the political parties?
Yes.
And that they were agreeable to how these matters were resolved?
There's a process. The commission sits as a tribunal. When the commission looks at a complaint and deals with it, communicates to the complainant, if the complainant is not satisfied, there's a way of dealing it. It's by way of appeal to the High Court. In the similar manner that in all cases, you will begin with the magistrate court. If the judgment is not, you are not satisfied, you appeal to the High Court. If you are not satisfied at the High Court, you appeal to the Supreme Court.
Yes.
So you see, the law foresaw all this, that the commission sits as a tribunal, and the decision of the determinations of the tribunal are appealable to the High Court. So when we dealt with all the complaints and gave determinations in writing, giving reasons, those that were satisfied, I believe they did not proceed, but those that were not satisfied, they've got a right of appeal to the High Court. That's how cases everywhere are done.
Out of curiosity, as an ordinary citizen, am I able to access these resolutions of the queries that were made, just so in case I'm interested to see how the matters were resolved?
Yeah, I am sure.
Yeah.
I am sure.
This is an exclusive
because
interview.
Those are the letters that were written, and if you want to see them, you can see it's a determination. And the determination gives the reasons how you reach to, and that it's, you know, it's a determination because we are saying it's the tribunal.
Exactly.
But when it's a judgment, a court, we say it's a judgment.
Yes, yes.
And if it's a preliminary case, a preliminary issue, we say a ruling or an order. So, but in a ordinary language and understanding, these are judgments of the commission that give reasons on how we reached the conclusion that we reached.
This is an exclusive interview with Justice Dr. Jane Ansah, the chairperson of the Malawi Electoral Commission. We're going to be right back. Welcome back. This is an exclusive interview with the chairperson of the Malawi Electoral Commission, Justice Dr. Jane Ansah. In the course of giving updates on the election results, on 25 May, the Malawi Congress Party obtained a court injunction that had two orders. And the first was staying the announcement of the presidential election results. The second was recounting of ballot papers in the presence of representatives of political parties which contested in the elections in a transparent manner in 10 districts, and I'm sure we all know those 10 districts. Now, we see you adhering to the first order, which was to stop announcing the election results. But what I'm curious to know is, did you start recounting the votes?
We didn't.
Is there any particular reason you did not do that?
That order, it was an order of an injunction. An injunction is a temporary order. It does not give the final order to be done. And the final order is done after judicial review. So that injunction was to work up to the time when judicial review will be held. And when a judicial review is done, it is both parties presenting their parties. So an injunction, it is just a temporary order pending judicial review.
But we still see you adhering to the first order of that injunction, which was staying the announcement of the results.
Yes, because the announcements of results was to be stayed waiting for a judicial review hearing. So that was before a judicial review hearing. It's the judicial review hearing that at the end, it will review the process and say this is the way you should go. The way you should go, you should either go and recount as they are pleading or not. So an injunction, it stops you from doing something until a judicial review. The thing is reviewed. And after review, that's when an order will be given. So my reading of that order was that it was an injunction, pending hearing of a judicial review to recount if it was successful.
Would it be wrong to conclude that MEC was in contempt of court from the time that this injunction was served to the time that it was vacated, because it indeed stayed the announcement of the results but did not set in motion processes to start recounting the vote?
No, I don't think MEC was in contempt.
What would have needed to happen for the Electoral Commission to start recounting the votes? What was needed? If it wasn't this order that the MCP got from the courts, what was needed for you to start recounting?
We needed an order for for recounting after hearing of the judicial review.
Yeah, but I'm still struggling to understand, because the injunction that was served to me had two orders. And I do fully appreciate what you're saying, but I'm still struggling to understand, why would the MCP call for a recount of votes in the 10 districts and also bind you from announcing the election results? And we see you stopping the announcement of the presidential results, but not adhering to the second order. So that's what I just wanted to understand.
That's what I'm telling you.
Yes.
That according to my understanding of the order, an injunction stopped us from announcing a result.
Yes.
Pending or waiting for the hearing of a judicial review procedure, a hearing, that there was a need for recounting. So that had not been heard.
Okay.
You know, the judicial review, it is not done ex parte. When we say ex parte, it is not just one party that will go and say, this is my problem, this is my complaint, now decide on it. No, the court process always deals with both parties.
Yes.
And it is only in special circumstances that they will entertain an application by one party. That's why when there was an application to vacate the injunction, which could have been done ex parte by make alone, but the court ordered that it should be inter partes. Both parties should be there. He must hear from this side and also that side for them to come up with an order. So that order, I'm saying it was for an injunction, pending, waiting for the actual hearing, which would have brought the order for a recount.
If that order had been made, was the Electoral Commission ready to recount the vote?
Yes, definitely. The Electoral Commission respects the judgments of the court.
When MEC lawyers were seeking to vacate this injunction, what were their arguments? What exactly were they trying to achieve? Or what were they against?
But that ruling, it's in the public domain.
I want to hear how you understood it.
You know, the law, the judgment said, according to the law, once the results process has started, it cannot be stopped. So that's how the ruling came. It followed that law.
It should be in the interest of the Electoral Commission to ensure that everything is done in a fair and credible manner. And in an instance where one party feels aggrieved and says, can we stop this and make sure that this is addressed? I would expect the Electoral Commission to say, oh, by all means, let's go ahead and do that. But that's not what we see the Electoral Commission doing in this case.
The Electoral Commission does not come up with its own laws. But within the law, which is given to the Electoral Commission to work, we come up with the procedures. So we will not go outside the law. We are guided by the law. So we looked at the law and we said, let the law guide us.
The MEC lawyers were arguing that MCP erred in rushing to court when the Commission was not given the opportunity to resolve grievances as directed by the High Court. Is this a right capturing of what exactly was going on at that time?
Yes, they had given in a complaint before the MEC gave a feedback. They went to court.
And this is what you had a problem with?
I've said we work within the law. And the law makes all that provision.
Because to me, from where I'm sitting, it looked like the Electoral Commission was not keen to adhere to this injunction and go ahead and recount the vote. That's how I see it.
No. The Commission adheres to the law and operates according to the law. So we look at the law and operate according to the law. The law is the one that has made the provision that the MAC should receive complaints, and when the complaints are come, it should look into them and give a feedback. And the MAC cannot just receive a complaint now, and the next minute, without doing the necessary work, you give a complaint, you give a feedback. You have to follow through the complaint. And this was made very clearly when I was giving the update. After following through, I came and updated the nation. We received this complaint. This is how we have handled it, and this is the final outcome. It was there, very clearly, that I gave the update. Throughout, we gave the update. Even for the 147, we gave an update. Go back to the recordings, you will find them.
Correct me if I'm wrong, but for most Malawians, this is a case of deja vu, because in 2014 we had similar scenarios. And in that time, I remember that MEC argued that it would not release unreliable results and that it was willing to recount all the 4 million votes at that time and announce the results in about 30 days. But what we see the Electoral Commission doing in 2019 doesn't seem to be in the interest of the majority that wanted the vote recounted, because I think in the first instance in 2014, it is clear that the Electoral Commission was keen to recount the vote and announce the results later. But in this instance, it looks like the Electoral Commission is not very keen to do just that. Instead, it's going ahead to vacate the injunction so that it can go ahead and announce these results, which by now are in contest.
But that is also what happened in 2014. There was an injunction or 2 injunctions. Mm-hmm. They were vacated at what time? And that is when the results were announced. I believe it is important, really. I do not think each and every Malawian can be a lawyer and they can follow through. But when things are being explained in a simple language, it will be in the interest of all Malawians to really follow through and understand, but not to be selective in what is taken and the other things are left out. Because, you know, Malawians are saying something different from what others have seen from outside. Someone from the Commonwealth that I met said the way the process was, it is a very good example which the Commonwealth should emulate. Malawi is one of the first few countries in the world where they have used auditors in an effort to be transparent. When you look through the whole process, it is so transparent. Nothing was done under anything. For example, I even encouraged the stakeholders, and in particular political parties, to have their own tally centers so that they can tally. Why did I encourage them to have tally centers? Because I knew that they gave us even the names of their monitors. And the monitors were trained with funding from UNDP. And we expected that as the monitors participated on behalf of their candidates or political parties, they will have the results. Apart from that, the results, one of the processes was that as soon as they count and the results are known, apart from giving copies to the monitors, the results will be posted at the polling center. And these days, people, they capture everything with these cameras from the phones. That's why we see a lot of things flying around in people's cameras. So, if we did that, it means the whole process was so transparent.
I do agree that we are not lawyers, all of us, and but that's why I want to hear what your comment is on what Judge Mkandawire observed. He observed that MEC was aware that MCP had logged a complaint on irregularities in the presidential election, but the commission was going ahead to announce results before addressing the complaint. Would you agree with this observation?
No, I will not agree. I will not agree. Because the way we are processing the results, there was no way we were going to announce the results on Friday or even Saturday. When we looked at our workload, we were thinking that the results most likely will be announced on a Sunday or on a Monday, 26th or 27th. And for Judge Mkandawire to make that observation, because maybe what he was given, but we had not attempted to announce results at all. What we are doing, we said we will keep the nation informed of where we are. We will announce the results as they come. We are going to announce results at 35%. We said 25%, 50%, 75%, and 100%. And you remember the process. The process was that when the results are received, they will be printed. The first desk the results will be taken to is the auditors. So the auditors will audit the results and then put their stamp. After they have done that, they will give that to MEC officials, who will also look at the results, process them, look at them, and verify that they are okay. They will put another stamp and initial. After that, they will send to the commissioners for endorsement. But the commissioners did not just endorse. We also looked at every result sheet. And after that, it was stamped and initialed, sent back to the MEC officials. Then they will print the results and share with the political parties. And I think even journalists were given. Why at that time were we giving to the political party representatives? For them to audit the results. And where were they going to audit the results with? By the results that they have received from their monitors. So they will look and say, this is what we have received, check against it, and then they will know this is the same. And at one briefing, there was a result sheet, I think somebody was querying, and I took the original. I was reading the numbers, the figures, to one journalist. And I said, are the figures the same? Yes, they are the same. And yet, that result sheet, they said there was a query. The figures were different. What MEC had and what they had was different. But in the presence of everybody, to the hearing of the whole nation, I had what we had and what that journalist had. The figures were exactly the same.
It's interesting that you should talk about result sheets, because there have been allegations that MEC officials were not giving the result sheets to the political party monitors, especially at the early stage of counting the vote, like at polling stations. Are you aware about this?
Well, that is one of the issues that is before the court. And I would plead with the nation and everybody to have patience and allow the court to do its work.
When the injunction was eventually vacated, I remember you were at the middle of addressing a press conference, and then you received communication that the injunction had been vacated, and you said you would take a quick recess of about 10 minutes and come back to essentially announce the results. So it is my assumption that at this time you had the final results with you, but you were just waiting for the courts to vacate the injunction. Am I right to say that?
Yes.
And when you took that 10-minute recess, which I think was a bit less than that, what did you use that time for?
We went to look at the address that had been made. Mm-hmm. Yes.
Did you make efforts to find out if the MCP had already been served with this notice of the vacation of the injunction?
Notice of the injunction.
Did you verify if the MCP was aware that the injunction had been vacated?
You know, the injunction was vacated at the court. Mm-hmm. Both lawyers for the MCP and the MEC were there at the court. Mm-hmm. And from what I understand, the court did not read, but gave